Okay, we ready?
Mhm.
Okay, I'll call this meeting to order. It is Wednesday, August 27th. It is 10:30 a.m. and we're here to discuss and review and consider a resolution to accept a right-of-way and dedicated as a public right-of-way portion of Siberts Road. Before I put this into a public hearing, I want to go over a few rules. There's a signature sheet that's went around. No person shall be permitted to testify or speak before the hearing body and public hearing unless such person has first signed his name and address to the sign-up sheet provided by the hearing body and indicated what, if any, interest he or she may have and whether he lives within or she lives within 300 feet of the property being considered. No person shall be admitted to speak before the hearing body until such person has been recognized by the presiding officer. All public hearing proceedings shall be recorded electronically, and people shall speak clearly and loudly to assure that the testimony is recorded clearly and correctly. No person shall interrupt the speaker. The speaker who has evidence, any speaker who has evidence of any kind shall submit that evidence to the staff to be entered into the record. 4 copies of each document or photographed item of evidence shall be provided and shall be marked for identification purposes. People attending the public hearing shall engage in a respectful manner. Any action taken that disrupts the proceeding or endangers others may result in prompt removal. Once the chairman declares the hearing closed, no further testimony or evidence will be considered. Anyone who fails to comply with the rules by the chairman would be asked to leave the hearing. Okay. I would entertain a motion to go into public hearing.
So moved.
Second it.
Roll call.
Commissioner Cowles?
Here.
Commissioner Zimmerman?
Here.
Commissioner Duff?
Yes.
All right. Okay, I can see the sign in. Okay. Okay, as per the agenda, the first case that we're hearing is
Do you have a resolution number already picked out?
do we have a resolution number?
Yes.
There's a way to identify it.
38.
38?
Yes.
So it'd be
25-38.
Yeah, and so it's 2025-38. And it's for Roger Titus. And the board doesn't have any conflicts of interest that we need to bring up, okay? Okay, so I'll have our planning and zoning administrator give us a
Rundown
on that.
Yeah. Well, thank you, Dan.
Okay. Do you solemnly swear to tell the whole truth and nothing but the truth, so help you God?
I do.
Okay.
Dan Martinson, administrator, planning administrator, for the record. This is a brand new one for all of us here at the county. We have not done an action like this before. So I'll go into a little bit of explanation. In general sense, what we're petitioning here is a resolution to accept a portion of road that the county already maintains and accept it as dedicated right-of-way, where this landowner will dedicate to the county this stretch of road. Now, the reason for that is in our subdivision ordinance, which is handed down through Idaho Code and the Land Use Protection Act, we get to, as a county, define what a subdivision is, so we do that through the minor and the major subdivision process. We also build into that, and all the counties do, a set of exemptions that exempts you from the subdivision ordinance when you have things like court decisions, government takings, where we're doing a road right-of-way expansion of some sort, we can go take a road, or for buildings, utilities, will and testaments, those kinds of things that some judgment comes down or some decision comes down to create a piece of ground, give it an identity, and be able to trade it. We don't have to go through the formal platting process. In that ordinance, we also defined back in 2009 when we did the subdivision ordinance, one of our methods for dealing with our properties here in this county is we have lots of properties that are in mining claims that stretch across rivers, stretch across highways and roads, public already dedicated public right-of-ways. And so effectively they're already bisected. And so what this exemption does is it allows people to divide one piece of property away from the other one based on the river, based on the highway road that goes through their property. And as long as the two pieces being created are compliant properties and we've met the process, administratively that's approved through planning and zoning. We've done numerous of these over the years. We do lots of them. We've never come upon one where we had a stretch of road that wasn't already dedicated to us. Or we do them through subdivisions, and through a subdivision process, that gets put on a plat, and it gets dedicated in the notes as this road is dedicated to the public. You guys sign this. When you sign the plat, you accept it in that method. And that's how 90% of the roads ever get brought into a road system, is through some sort of platting dedication process. This isn't one of those, but it is part of our subdivision process. So we kind of batted it around a little bit on how to handle this. Idaho code is fairly clear, and there's lots of sections that talk about vacating right-of-way that we already own. There's not a whole lot on how to accept it because it usually pushes it right through the platting process. But we dug through it, and that's where we ended up with, because the administration of the split is an administrative decision, we didn't feel like I had the authority to accept county assets as a road dedication. So we decided, let's put it on a resolution and then let it be a decision of the board to accept it. And then we'll do similar like we would with a subdivision, where we go to the highway district, which is our public works, and determine, is it our road and do we want it, and what is the status of that road. So we went through that process. And so that's what this is here, is this person has been approved to split the property. And the maps in your picture show there's a long stretch that's between the road and the river, and then there's a bigger piece that's between the road and the mountain, and between Highway 301. And so that's been, the deeds are ready. As soon as we get approval, then we can make this happen. But the decision to accept this strip of road that goes through there is what was in front of us today. So I went to Public Works right off the bat and said, hey, is this portion of the road your guys, and do you maintain it, and do you intend to keep maintaining it? And the answer was a resounding yes. In fact, I'm doing some bridge work this next year on that particular bridge. Some redecking has already been slated for that. Anywho, so there's a letter in the packet where they had acknowledged and accepted that it is ours and that they do wish to keep maintaining it. And in this case, the applicant is perfectly willing, of course, to dedicate it to us. So the resolution was created, pretty straight fair. Did go through Ben and Brittany on this format and wording to make sure it was good for them. And so that's what the draft is in front of you for this. What will happen is if approved, then they will initiate the recordings of the deeds and the record of survey, which will monument it. And then the deed of conveyance from that person to the county will come through specifically for that strip of land, and that's already been created in there as an exhibit.
Okay,
we just so happen to have another one coming at 11 o'clock. So we've had two of them come at the same time, and we're doing both of them similarly. So
we have no applicants, and we don't have any written testimony, but we have testimony, two neutral testimony. Mr. Beener.
I'll change that to against. I believe this is totally the wrong place to be doing this. I think this is a road validation hearing, not a whether we're taking the land. You can't tell me, I mean, how we got this property at all. It bothers me that we're actually maintaining it. Like I said, this should be a road validation hearing, not a whatever is on the agenda. I don't know what it is of getting this property. In fact, I don't even know if this is RS 2477. I don't know if the railroad owned this land at one time or what, but the road then. Okay. So yeah, this is their official road map system. Should have been done years ago, and we've never gone through that process yet. And I can tell you by going through the old minutes of the meetings, which we know the Jeep Club versus West Fork of Pine Creek. Let me think where I was going with that. The minutes of the meetings mean everything, and nobody yet that I know, except for me and Joe Avery, have gone through the minutes to find what roads are what. I absolutely think it should be a validation hearing, not take the property. Thank you.
Okay. Mr. McDonald?
I got nothing.
Got nothing? Okay. Okay, do we have any rebuttal?
All I could say to that is we did explore, particularly Idaho Code 40-202, and the second paragraph speaks to accepting right-of-way through platting process and accepting right-of-ways of areas we already maintain, and that was through the investigation with Ben and his office to determine the proper method for going through this, and we followed that code for the noticing in the process, and it was the resolution to come. Was the method for proposing it to be accepted. Not unlike when we do a plat, where we accept dedicated right-of-way that was always ours, or potentially was always ours. If he had done a subdivision where he was carving this up into multiple pieces instead of just bisecting it by the road, it would have been the same process of putting it on the plat as we would accept it as dedicated right-of-way, even though it was previously prescriptive, to determine prescriptive rights on a property. The element of determining prescriptive rights is, have we spent money maintaining it? Have we actively maintained it in the last 5 years? And do we intend to keep maintaining it? And then are there improvements to need to be? Because sometimes we have some not so great roads out there that if we were going to take it in, this would be the time to ask for road improvements, or maybe to have the road built up to a better standard. Mm-hmm. In this case, the road was at the same standard as we've been maintaining, and there was no improvements needed or required, but it's the same process, and so that's why it's not a validation of a road that is in question on whether we own it or not. It's the old railroad grade. It was passed down and shifted between entities for 100 years. Somebody's been maintaining it. It's been the county highway district for as long as anybody can know. So, and it's not in dispute. So.
Okay. Now, just one quick. I just have a quick question on that part of the road. Do we have the other parts of the road as well as?
Prescriptively, we maintain the road. We do not have dedicated right-of-way elsewhere because we've never forced it, and we've never had an applicant request a development that would allow us to say, hey, by the way.
So the other parts of the road we don't have.
We don't have dedicated right-of-way to, but because we've been maintaining them and actively maintain them, we prescriptively have the right to keep doing them.
So we'd have to do some kind of if we had prescriptive, we would have to, I understand. We'd have to purchase it, but this guy's dedicating it.
Correct.
Yeah.
And the rest of it, if we did a government takings process, where we went and said, hey, we're going to take over this road and we need 50 feet of your property for whatever reason, we would have to demonstrate that we've been maintaining it, that we want to maintain it, and that we intend to keep maintaining it, and then we would win that judgment. That's usually not contested because of that very blatant, once we've been spending money. It's different when haven't been maintaining it for years, we haven't been ever maintaining it, and then we get into another discussion. But and that's where the 202 does speak to accepting roadway via the highway district, which is
Okay. Does any of the other commissioners have any questions or anything they want to have answered that we haven't touched on
Pretty
yet?
clear.
You said. Okay.
So we have been maintaining this for years?
yes. I don't know the amount of time, but
Okay.
Okay. Okay, if there's no further responses.
Oh yeah, I do.
Okay, yeah,
I'm
a
not
rebuttal.
shouldn't have
Can we
back
do?
and forth, but
Can we do a rebuttal? Okay.
I'm not disputing the guy has the right to dedicate the road to him, but how do you get to that road if you haven't validated the other road?
Okay. Thank you. Okay. Are we ready to make a decision?
We need to move out of
The public hearing?
Mhm.
Yep. I would entertain a motion to close the public hearing.
So moved.
Okay.
Seconded.
All in favor?
Roll call.
Roll
Roll
call.
call.
Commissioner Cowles?
Here.
Commissioner Zimmerman?
Here.
Commissioner Dost?
Yes.
Okay, we're in regular session. No other information can be said or given. What does the board feel? Do we have any discussion that we want to discuss on this?
I have no objection to the resolution.
Okay. Mr. Cowles?
I have no objection to the resolution, but I do think that there was a point brought up. If somebody were to shut her down on one side of that road that's privately owned, and how would we maintain that other? I guess it could just,
We'd probably have to, that bridge would
Yeah.
have to be crossed at that time and in order to.
just something to keep in mind, I guess.
Yeah. Yeah, it would be something we'd have to keep in mind. Because that would be a bridge we'd have to cross
Yeah.
at that time. Okay. Okay. I would entertain a motion.
I move we approve the resolution to accept this roadway as a dedicated public right-of-way pursuant to Idaho code and identified as a portion of Siberts Road.
Okay.
I'll second it.
All in favor?
Aye.
Aye. Okay. It's passed.
Very good.
Okay, meeting adjourned.
Thank you.
Thank you.